Number 67, John W. Terry et al., Petitioners versus Ohio.
So this is everything you need to know about Terry versus Ohio.
Then the man can go on off, not answer questions, because the officer doesn't have at that time sufficient amount of evidence to make the case of probable cause of guilt of committing the crime.
That's precisely what I'm saying.
Hugo Black is born in 1886, 10 years before legal segregation in Alabama. There's 16 lynchings in Alabama before he's 10 years old. And then in 1896, when he's 10, legal racial segregation begins, the beginning of Jim Crow laws. And what has Hugo Black seen his entire life in Alabama? The Jim Crow Act, which means black people are feeble-minded. Their brains haven't evolved all the way. He's the senator of Alabama from 1927 to 1937. Hugo Black is appointed by Franklin Delano Roosevelt in 1937. And from 1937 all the way up until 1964, Hugo Black has not applied civil liberties to black people. The Supreme Court has not applied civil liberties to black people. So in 1968, that's the reason why you hear Hugo Black saying the things he's saying. Of course black people have to answer to police. His entire life they haven't had a Fifth Amendment right. It's a shocker to him to hear that black people would not have to answer questions to police. I mean, go back and listen to what he says here.
He wants to do something short of a list, but cannot get an answer and do nothing about it.
Suppose he wants to do something else. What is that? What do you mean? What do you mean do something else? What does that mean exactly? What does that mean exactly? What does that mean exactly, Hugo? What do you mean by that, Hugo? Hugo, what do you mean by that? What do you mean by that? Well, we know what he means by that.
I said can ask him a question, but cannot get an answer and do nothing about it.
You can't talk about Terry versus Ohio unless we talk about the Warren court. Earl Warren is facing impeachment by the police. They're picketing up and down the freeways saying impeach Earl Warren because he passed Mapp versus Ohio, which is the start of the exclusionary rule, that police can't just run roughshod over your civil liberties and then present evidence. It's called fruit of the poisonous tree. They got evidence off of you by violating your civil liberties. Mapp versus Ohio stopped that, and the police hated him for it. They hated Earl Warren for doing that. You can hear it when he talks. You can listen to his voice during the Terry trial that he is taking a dive, essentially.
Folks, I wonder if that's going to be broken down a little. I wonder what you would say to this. Of course, a police officer does have the right to investigate a crime. And this police officer, in this instance, had the right to investigate crime.
What was John Terry's crime? What did he do wrong? He was walking around on the street in the daytime talking to other people. It's 2:30 in the afternoon. He's walking around on the street speaking to other people. And they had a conversation. And then he went over and talked to this man. And they had a conversation. And then he stationed himself over there.
He did see what, one might well say, were suspicious acts on the part of people whom he thought might be preparing to commit a crime. He had a right, did he not, to pursue that farther, to determine whether or not he would have probable cause, perhaps for an arrest.
He said that police have the right, do they not, to walk up to you as you're minding your own business and investigate you. No, Earl. No, they don't. And why does he think that way? He's born in 1891. Earl Warren is supposed to be the defenders of our civil liberties, our right to be free. And instead, he's saying, don't police have the right to walk up to you and question you on the street? That's what he just said.
Pursuant to that, he went to talk to these men. Now, because of the nature of the crime, that he suspected a robbery, he felt that when he went into the company of these three men against himself alone, that he was in a dangerous position.
No, McFadden never said any of that, Earl Warren. You did. You made that up. You made that up with the other white Supreme Court justices. He never said he was in fear for his life. It was the middle of the afternoon on Halloween. There were hundreds of people around. McFadden never feared for his life. You guys created that. You made that up. It's not in any transcript. McFadden never says he was in fear from his life from three black guys. It was two black guys and one white guy named Katz.
and that that therefore he had probable cause to see if they had weapons on, not because he had probable cause to believe they had committed a crime, but because in investigating the matter, he had probable cause to believe that his life was in danger.
I think it's important that you understand what probable cause is. Probable cause is when you have broken the law. That's what you can get arrested for. Probable cause supported by oath is when a cop sees you break the law. Or you've created a victim out of someone, you've assaulted them, and they called and they're swearing by oath that you committed probable cause and you broke the law. I just want you to understand, probable cause is when you have broken the law. You crossed on a red, someone called and said that you assaulted them. Earl Warren saying that the cop has probable cause to see is actually impossible. The words don't make sense. He's making things up as he goes.
Under those circumstances, would you think that he did or did not have a right to ascertain whether he was in a position of danger by seeing if they had weapons?
Well, only if we're going to relax the standard of probable cause as we know it under the Fourth Amendment.
As you can hear, Earl Warren is doing absolutely everything to work against our civil liberties to be free. He's working on the side of officer safety that was never brought up. McFadden had zero fear of those guys on the street. It was broad daylight. He felt completely entitled to walk up to them and bully them and push them around. It was never about officer safety, so it's astonishing to listen to Earl Warren push this argument for officer safety over your civil liberties, because the functionality of the Supreme Court is supposed to be to defend our civil liberties at all costs. Defend the civil liberties that are your God-given rights. Listen to this next part carefully. Thurgood Marshall is going to give the best arguments there are as to why this case shouldn't even be in court. And then he's going to destroy Martin McFadden. He's going to destroy his character. He's going to destroy his ability. He's going to destroy everything about Martin McFadden. You have to listen carefully.
Well, Mr. Payne, in this case, this arresting officer testified, did he not, that he had never seen anybody case a joint.
That is correct. He did so testify.
He also testified that he'd been on that same area for some 30 years doing the following things: checking for pickpockets and shoplifting.
That is correct.
So where did he get his expertise about somebody's about to commit a robbery?
I think that he would get his expertise by virtue of the fact that he had been a member of the police department for 40 years. And by being a member of the police department for 40 years, I'm quite sure that even if by osmosis, some knowledge would have to come to him of the various degrees of crimes.
Now we get intuition by osmosis.
Not at all, sir. Not at all. Not at all. I did not mean, I didn't mean to imply that, nor did I mean any disrespect by so using that particular term. I think that, for example, if I, as a lawyer, am around a particular office for a number of years, that I certainly must gain knowledge about various concepts of law that may come about from time to time.
There are exceptions to that.
I would agree with the court in these circumstances also.
It's a funny joke, right? The thing is, though, Reuben Payne is correct. Reuben Payne is spot on in his analysis of learning policing, being on the job for 40 years. Remember, Martin McFadden's job up until from 1924 to 1954, 20 years, was to enforce black codes, which meant to instill fear in the black community, and to be suspicious of black people and to arrest them. After 1954, there's a no man's land from 1954 to 1964. In 1963, Martin McFadden says he's suspicious of John Terry. He doesn't like how he looks. What had he been doing for the 20 years before 1954?
Well, seriously, Mr. Payne, the point is that the only thing he noticed was a man leave from position talking to another man and go across the street, look in the window, and go back.
I disagree.
Now, number one, you'll agree that everybody that looks in a public window is not casing a joint.
Agreed.
But they did do it twice or three times. How many times?
It's
not too clear to me in the record.
May I then, in response to the Justice's question, indicate, first of all, and clarify this,
His testimony was not that he didn't like them. His testimony was that he didn't like their looks. Now, I don't think that he meant by that any reference to pigmentation or anything else.
And anyone with two eyes in his head and with roughly normal vision can look around him and see that there's a vast and permanent difference between the white and colored people. That, as Abraham Lincoln so wisely said a number of years ago, would forever prohibit them from living on terms of equality in the same society. That, just in a nutshell, is the reason.
I think that he meant by that, when we take the entire record into consideration, the fact that this was in a downtown area.
But didn't your own court say they still did not have probable cause for arrest? As of this point, we're now at.
The trial court indicated that at this point that there was not probable cause for arrest. The appellate court did indicate that there was probable cause for arrest after the frisk took place.
No, I mean, well, we haven't frisked him yet.
That is correct.
So he didn't have probable cause to arrest when he approached.
I would agree with this.
And he didn't get probable cause to put his hand on the butt of the gun.
He didn't get probable cause to arrest
him until he put his hand on the butt of the gun in his inside coat pocket.
No, sir.
Counsel for petitioner says he didn't have it when he laid hands on him and turned him around.
I would agree with... He did not have probable cause to arrest.
Right.
I would agree that he would have probable cause to frisk or to lay hands on him at this point.
Why?
Because of the nature of the circumstances and protection of his own life.
He didn't see a bump go. He didn't say he saw a gun bulging or anything like that.
No, he did not say that he saw a gun bulging. He indicated that they were casing a joint for robbery, which implies a crime of violence, which implies that they have a gun, which implies a crime of violence, which implies that they have a gun.
And then Thurgood Marshall will vote for Terry laws.